Hi there. Welcome to Inheritance Disputes and Estate Litigation, Washington TEDRA Attorney. My name is Austin Nowakowski of Nowakowski Legal, PLLC, a Seattle, Washington-based law firm that places a special emphasis on inheritance disputes and estate litigation, much as the title to this show may have led you to believe. In Washington, these type of matters are generally handled under a special subset of Washington law. Its statute number is RCW 1196A, but it's more commonly referred to as TEDRA. TEDRA stands for Trust and Estate Dispute Resolution Act, and the best and easiest way to think of this is that anything that has to do with an inheritance dispute, a will contest, a probate dispute, or a trust dispute, or anything that has to do whatsoever with a contest or a litigation in regards to inheritance, this would generally fall underneath the avenue of a TEDRA proceeding. TEDRA also handles a couple of other items as well, such as guardianships or power of attorney matters, and a few others that come up sometimes and that end up getting filed under through a TEDRA petition. But again, for the most part, the best way to think about it is if you have an inheritance dispute, TEDRA is the specific subset of law in Washington that you would use to bring a action and to hopefully have it resolved. There's more information on what TEDRA is and the backgrounds of TEDRA in my two previous videos. If you'd like to review those, you're more than welcome to. If you really want to know a lot more about it, you're welcome to contact me, and I'm happy to tell you all about it. But today's video is going to be more about the actual filing of a petition in TEDRA. There's a couple of small differences between filing a petition in TEDRA for an inheritance dispute and a normal civil action. The first thing is, normally in a civil action, you don't file a petition. Normally you're filing a complaint. A petition is more or less a request of the court, is generally the way that I usually think about it, whereas a complaint feels more that you're actually bringing a dispute before the court. For all intents and purposes, a petition in TEDRA is very similar to a complaint. You're still bringing a dispute before the court that you want to have resolved in regards to an estate or in regards to some inheritance dispute of some way, shape, or form. But still, there are some subtle differences. The biggest difference between a normal civil action complaint and a petition filed in a TEDRA matter would likely be the fact that a TEDRA petition will normally have more substance to it. It'll normally have more of a story put into it. It'll be more thorough. It'll be more of an explanatory document that's actually putting forth legal argument. It attaches evidence. It attaches affidavits for provision of testimony, and many times the petitions will be verified by the petitioner that's signing, for purposes of being able to give it that extra evidentiary oomph of it also making allegations throughout that they're swearing to. The reason for this is actually that sometimes, and actually it's not sometimes, I'd probably say 20-30% of the time, TEDRA matters are resolved disputed TEDRA matters are not resolved, but they're ruled upon on the merits at the initial hearing before a commissioner in the probate department. What this means is that if an attorney or if a party isn't ready to basically explain to the court their position and to back it up with at least some evidence that's in their favor, there's a possibility that at the initial hearing, the judge could rule for the petitioner or for the respondents, and that would be it. Generally, if there's some questions to be had, or if there's still more information that's needed, or if it's clear that there's just a larger dispute than can be handled in a 10-minute hearing, the commissioner or the court will actually set the matter on a trial schedule, which is an interesting thing that I'll talk about in a different video, because the trial schedules are actually more or less agreed upon between the attorneys, and the court doesn't really put too much into it. They just kind of say, hey, you guys figure out what you want the trial schedule to be. And anyway, so the bottom line is that your petition has to have more information in it. Think of it kind of, and if you're not an attorney, you might not understand this, but think of it as a combination between a normal complaint and almost a motion for summary judgment, where you're trying to put them both together. You're attaching evidence to it initially so that your initial hearing, or your appearance in the initial hearing, you'll actually be able to convince the court, if necessary, or if they're willing to allow it, that, hey, here's all the evidence, here's all the information you need, please give me a ruling today. Again, it doesn't always happen, but if the other side is unprepared and one side is very prepared, there's a possibility that the prepared side, who has all of the evidentiary requirements and has a concise argument placed together, might walk out that day with a judgment in their favor. That's the number one difference between a normal civil action complaint and a TEDRA petition, at least in my opinion. So how do you put together a TEDRA petition? How are the actual parts of it put together and labeled throughout? Well, again, it's very similar to most filings that go on in a court. So, don't think that you have to go too far outside the box in order to put together a TEDRA petition. Standardly at the top, you have in the King County Court, in the Washington Superior Court of King County, depending on whether or not it's based off of an ancillary action, or if it's its own action, you might put the name of the ancillary action up there. For example, a lot of TEDRA petitions are based off of a probate that's ongoing, or they're based on a trust that there's an issue with. So you would put in the title heading of the case, in re estate of whomever the name of the estate is, or in regards to the trust of Jane Smith, and that would be the primary title heading. And then what I do, and I've seen attorneys not do it, but I like to do it because it does at least make a clear statement as to who the petitioner and who the respondents are, is underneath that I like to put the petitioner's name, mark them down as petitioner, versus, and then the respondents' names, mark them down as respondents. So that way it's very easily identifiable as to who all the parties are. Underneath that, you're going to have your standard wherefore clause, wherefore, John Smith, by and through his attorney, is bringing this action against the respondents, etc., etc., etc. And then, very much like most complaints, you're going to have the parties and jurisdiction section. The parties and jurisdiction to most TEDRA petitions are essentially anybody and everybody that has an interest in the subject matter of the action. I know that sounds relatively broad, and also it sounds very, very similar to most complaints, but you have to think a little bit more broadly in regards to TEDRA petitions. So, for example, if you were bringing an action against a trust and you had an issue just against the way the trustees were handling the matter, you can't just bring your TEDRA petition against the trustees. You also have to name as the respondents every single person that's interested in that trust. So this would include the other beneficiaries. If the person that created the trust is still alive, you might have to name them. If there are additional trustees that you don't have a problem with, you might have to name them. If there are trustees that haven't even taken their part of the trust yet, you would probably have to name them as well, because any changes or alterations to the trust, including the removal of a trustee, would ultimately affect them as well. So everybody that has some kind of a stake in the subject matter has to be provided notice. So that's the primary thing with the parties. You need to make sure that you name everybody that would have an interest in the subject matter. So again, for a will, everybody in the will needs to be named. There's a couple of subsets to this. There's a special representative clause that you could always have a special representative appointed for somebody that would either be a minor or incompetent or not able to represent themselves, and then that person could be served or would need to be served for purposes of being able to represent that individual who's unable to represent themselves. There's also these things called virtual representatives, which kind of make it a little bit easier to name a group of people that are either aren't that interested in the matter or are very difficult to identify. Virtual representative allows you to essentially serve or notice somebody else on behalf of whomever the person that is being virtually represented is. In regard to jurisdiction and venue, most of the time this is relatively easy to determine because you are already going off of a probate matter, so you know the court that the probate matter is filed in, and that will provide you immediately with jurisdiction and venue as to where you would be filing that. There is extensive information in the Washington statutes that would more specifically define where you can, or I'm sorry, whom the courts have jurisdiction over and where you could file. The two RCWs that specify that are actually, let's see here, RCW 1196A.040 and 1196A.050. If you're interested or if you need to be more knowledgeable as to whom they have jurisdiction over and what gives them subject matter jurisdiction and where the venue of an action should be held. Once you've gone about naming the parties and after you appropriately cited as to why you have, or why a jurisdiction and why a venue is appropriate, then you're going to actually go into somewhat of a background facts section, or at least that's the order of the, or at least that's the order of how I generally do it. This can be done in a multitude of different ways. You could do what you do in most filings with the court, where you just keep it enumerated. You just go from line to line to line. I like to go in almost a storyboard fashion, so that it's a timeline of events that are going from the first thing that happened all the way through. It usually helps to provide the reader with a little bit of a more context and understanding as to how things built down the line. But a lot of attorneys also like to just abandon, at least in TEDRA petitions, in this facts section, a lot of attorneys like to abandon the numbers, and for the general background and facts section, they will literally write out paragraphs basically telling a story. Again, this kind of goes to the mixture of a TEDRA petition kind of being the mixture between a complaint and a motion for summary judgment, or motion for judgment on the pleadings, or something along those lines, in that you're actually telling the court your position, your story, and kind of putting argument into it on top of your allegations. Again, the facts section is still just the facts. You're not really getting into the actual allegations yet, but you can start to allude to them. In addition, in the facts section, you're also going to want to be referencing any evidence that you're attaching, any affidavits, a copy of the trust, if there's a trust involved, a copy of the will, if a will is involved. You're basically going to use that section to set forth all of the background, all of the facts, to kind of tell the story as to what happened that your petition is actually bringing to the forefront, or that is actually taking place. After that, then you start getting into your individualized allegations. Again, TEDRA disputes generally cover will contests, objections to personal representatives, mishandling of probates, mishandling of a power of attorney. So you'll actually start getting into your individual allegations at that point. So the first part, with all the facts and general information, that's kind of the area where you pull the what happened from, and then the actual allegations are then the individualized illegal or wrongful things that the respondent did. So for example, the first one, let's say it's a will contest. You would reference the background information. You would say, on so-and-so date, a 2010 will was created. It was properly executed. It had both witnesses. The witnesses signed affidavits acknowledging that they had witnessed the matter, etc., etc., etc. It's a perfect will in 2010. Next paragraph, in 2012, another will was written. It was handwritten. There was no witnesses. This is the will that was provided to the court. We're contesting the 2012 will because it was not appropriate, and we're requesting that the 2010 will be put into place. So that would be allegation one. Additional allegations could be for maybe there was undue influence by one of the beneficiaries, and you're trying to bring that matter up. Perhaps there's a guardianship that's been filed, and you don't want the person that's being appointed as the guardian to be the guardian. So the allegation sections are then going to have your individual items that you are bringing complaint against. So it kind of takes the information from the top, and then it streamlines it specifically to what your actual problem is. So you'll have probably several different allegations. Usually I like to put them in order of what I believe is going to be the most successful, down to what I believe is still a valid argument, but is just probably not going to be given as much attention by the court, or might not be as interesting, or might not result in as good of a outcome as the other ones would. So that would be the allegation, or the counts, or whatever you would like to call them. Directly after that, you'll do something very similar to the allegations or the counts, and you'll put down demands. But the demands are usually a little bit different. Demands are usually based more off of actual statutory provisions that you aren't really, I guess, complaining about. You're just requesting that they be done, or you're demanding that they be done. For example, you can put a demand that this be sent to trial. You can place a demand that this be sent to mediation. You can place a demand that discovery be allotted. If it was a power of attorney and the power of attorney allowed for an accounting, you would place a demand that the accounting be done on the agent of the power of attorney to find out what they did with all of the finances of the person whom they were supposed to be taking care of. There's a heck of a lot of things you can actually put forth in the demands, but the best way to put it is the demands are more for things that you're essentially making a statutory request for. After the demands, you would then go into the actual prayers for relief. The prayers for relief are essentially what you're asking the court to do. So, for example, if you had a will contest and you wanted the 2010 will to be the one that's utilized, and you didn't want the 2012 will to be utilized, your prayer for relief would be that the court find the 2012 will to be invalid, and that they substitute the 2010 will in its place. If you didn't want the person that was appointed as the personal representative to act as a personal representative, you would ask that the court remove the personal representative and replace it with somebody else. If you believe that there is a monetary issue, you would request that the court essentially provide for whatever monetary issue there might be. Normally speaking, if the one that comes up a lot is if the personal representative absconded with a bunch of money, you would request that the court require the personal representative to essentially pay the damages back to the estate of the money that they absconded with, and be put back in there. And that would also likely go along with a objection to the personal representative as well, requesting that they be removed. But there's pretty much anything and everything that you would want to have be the result of the bringing the TEDRA petition that goes into your prayer for relief. Then after that, it's the easy part. You essentially just have your attorney put his information down there, he signs it, it's good to go, and that's all that there really is to it. Except that I would always advise, or I would most of the time advise, there would be some circumstances where I might not, that the petitioner, the person that's actually bringing the claim, that they actually verify the petition. This gives it a little bit more evidentiary, more of an evidentiary status. It makes it so that you can actually rely upon the words in the petition itself for that initial hearing. I would also attach affidavits of any witnesses that are going to be providing testimony should this go to trial, but if it doesn't, again, if at the initial hearing things are resolved at that point in time, you're going to want to have as much information sworn to as possible so that the court's able to make a decision in your favor. Again, many times the initial hearing is not the final hearing, and it usually is pushed over to a trial calendar. But in the event that you just have a commissioner that day that really wants this, doesn't really want this to go any further, believes that you provided way more evidence than is necessary to really prove what's going on, and that the other side didn't provide anything whatsoever, you're going to want to have all that information in there because you might walk out a winner that day. So it's a very wise idea to make sure that you attach as much evidence to your petition. I'm not going to say as much evidence as possible, but you're going to want to attach a strong amount of evidence to the petition so that you can be successful on that day if the opportunity is there to do so. Let's see here. So that is kind of a quick breakdown as to what would go into a TEDRA petition. It's again very similar to a civil action complaint, but it just is going to have more argument in it. It's going to have more background. It's going to have more reference to evidence. You're actually allowed to provide evidence in it, and it's possible that it could be it could result in a final judgment at the day that it's heard at the initial hearing. So you want to make sure that as much as possible is put into it when you file it. So that's pretty much it. Again, my name's Austin Nowakowski of Nowakowski Legal, PLLC. This is Inheritance Disputes and Estate Litigation, Washington TEDRA Attorney. I try to put one of these out at least once a month. I missed the month of December because holidays and craziness. But I should be back on track for the next several months, putting one out every single 4 to 5 weeks. If you have a specific area of TEDRA law that you would like me to focus on, I would be more than happy to do so. Just leave a comment in the comments below, or just send me an email. I think my address is probably popping up somewhere in one of the corners right now, and I'd be happy to do so. So other than that, thank you very much, and have a great day.